All right, appearances, counsel.
Next one on behalf of the people.
I'm Jeff Harrison. I'm here on behalf of Mr. Malley. He's joined me at the table.
All right, you may be seated. We are here for both a probable cause conference and a bond violation hearing. Counsel, based on the PCC sheet that was turned in, it does not look like we have a resolution of the underlying case. Am I correct on that?
That is correct, Your Honor. We've also requested that the prelim be set for April 7th as opposed to next Tuesday.
And the reason for that?
Well, there's some confusion, and this plays into this case as well, with regard to Mr. Malley was of the idea that he had retained an attorney, but no one has filed an appearance, but that's still up in the air. And I will be unavailable next Tuesday for a personal matter.
All right,
I will tell you if we're not being broadcast.
that's fine. I
Okay.
I'll take your word for that. And Mr. Carnes, any objection to setting out to the 7th?
No, Your Honor.
All right. So are there any discovery issues we need to address before that?
I don't believe so.
It looks like we've sent an audio recording and photos to defense, and it's a T&T case, so that's probably everything we've got.
That it appears to be complete. My only concern would be is if he does retain counsel, but we'll address that forthwith.
Sure.
Mr. Malley actually, as pursuant to our discussion, has indicated to me he would prefer to waive the prelim altogether. So we can file that paperwork with the court as well.
Okay, well, I will see what happens there. And that brings us to the bond violation. Then, Mr. Harrison, what's our plan for that?
Well, there's no doubt that he wasn't here, Your Honor. The question is why. So I believe that he will be prepared to make at least a limited admission, or like on the back of a speeding ticket, admit guilt with explanation.
So the allegations are that he failed to appear for a probable cause conference on March 10th, that he failed to appear for a drug test as ordered on March 9th, March 12th, and March 15th. Is the plan then that he'll plead to all those violations?
I reckon so. Do you have any reason why?
So basically, I tried to contact
Okay.
corrections place because
Hold on, we're not to that point yet.
Right.
Mr. Harrison, do you want a moment to talk to him in private?
No, I think he can make his explanation, Your Honor. He does have a probation hold on Manistee anyway, so it's somewhat academic.
All right, Mr. Carnes, any objection to taking a plea?
No, Your Honor.
All right. Mr. Malley, will you please raise your right hand as best as you're able? Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
yes, Your Honor.
So it's my understanding that you're planning to plead guilty to the bond violations, that you failed to appear for a probable cause conference on March 10th, that you failed to appear for drug testing on March 9th, 12th, and 15th. Is that your understanding as to what's happening today?
Yes, Your Honor.
All right. Then to those allegations that you failed to appear for a probable cause conference on March 10th, how do you plead? Guilty. And that you failed to appear for a drug test on March 9th, how do you plead? And that you failed to appear for a drug test on March 12th, how do you? Or is the recording picking up?
Very light.
Sir, I'll need you to speak up so the recording
Guilty.
equipment. And on March 15th, that you failed to appear for a drug test.
Guilty.
All right. Has anybody promised you anything in order to get you to plead?
No, Your Honor.
Has anybody threatened you in any way?
No, Your Honor.
And is it your own free choice to plead?
Yes, Your Honor.
Did you know, so is it true then that you failed to appear for the probable cause conference in this matter on March 10th?
Yes, Your Honor.
And did you also fail to appear for a drug test on March 9th, 12th, and 15th?
Yes, Your
Did you know about those drug tests?
Honor. I did not.
Why is it that you did not know about them?
So I tried to contact the corrections place because the address they sent me to go to in Muskegon didn't exist. So I tried to contact them. They never, every time I called them, it was a voicemail. So I had no way of knowing where to go to take these tests that they wanted me to take.
Who sent you that address?
The corrections place, the community corrections.
Our community corrections?
Yes, they gave me a Facebook page to look up
Mhm.
the dates for when I have to take my test, and then they gave me a address to a place in Muskegon called DNA that didn't exist.
Did you check the Facebook page to see whether you needed to test those days?
For those days, I did not,
Okay.
because for the first few times, it was nothing. For like a week, it was nothing. And then while I was trying to contact them the first day, they never got back to me, so I didn't know what I was supposed to do.
Did you only try to contact them once?
No, I contacted them multiple times.
Um,
The first 4 days, and those first 4 days, I didn't have to test.
and then why did you fail to appear for the probable cause?
So it was a miscommunication. Basically, I never got to speak with Mr. Harrison about him being my attorney, because when I got out, I was retaining Marie Vandenberg as my lawyer, and she told me she had spoken with
Public Defender's Office or the court clerk?
the lady, Joanna Carey. She said she had spoken with her. She sent her an email, but I don't think it was already probably too late for it. So by the time I figured out what was going on, I had basically had a warrant for my arrest. But I went as far as to trying to get everything situated, even by going with the bonds people to turning myself in back to Wexford.
Did you turn yourself in, or did they send a team after you?
No, I was doing everything they told me to do, and the team took me back to Wexford. It wasn't like they just retrieved me from somewhere.
The counsel believes the defendants provided a factual basis to accept the plea to the violations of the court rules being complied with.
Yes, sir.
As does the court, I find the defendant is in violation of his bond by failing to appear for the probable cause conference on March 10th, failing to test on March 9th, 12th, and 15th. That brings us to what we do with bond. Mr. Harrison?
Well, Your Honor, I think you can tell from his testimony that he is sincere to the extent that he did not have a complete understanding, the picture of what he was supposed to do. He never retained a lawyer before. And I don't know this Marie Vandenberg, whatever. He says that he spoke to her and either misunderstood what she told him or got that information. He's not gonna do it again. He had to come all the way back here and get tossed in the Huskow, which he didn't enjoy either, but it's part of the process and he understands that now. I think any lesson to be imparted with regard to his obligations under bond is registers loud and clear. We do need to find him a testing site if he goes back to Muskegon. However, I think Manistee is gonna come get him on their probation hold. They have asserted a probation violation. We're curious because we don't understand the timing of when all that happened. So I can't sort any of that out for you right now because I don't know it myself.
You mean is when the hold was put on him?
Yeah, right. Yeah, right. So it wasn't on him the first time he was arrested, but in the interim, they issued some, I think it's out on leave or something. So it's not, it's fairly complicated. I understand where he got in the weeds here. I made it clear to him today that when in doubt, call me. Until anybody else files a substitution, I am the attorney of record. He had some confusion about that before today.
Thank you. Mr. Carnes?
Thank you, Your Honor. I am concerned with the failing to test. Obviously, this is a controlled substance case, and then the fail to appear on March 16th. Do you think this kind of flight risk based on those factors? And also, we have this probation hold that's coming up kind of late. It makes me suspect he did not report law enforcement contact to the Manistee probation office. Again, that suggests he's a flight risk. I would ask the court to remand the defendant this time.
Has anybody scored him to see what his preliminary scoring?
Right now, as charged, it would appear that he would be something like 0 to 11, 0 to 17. His only prior that we were able to uncover was a delivery of a counterfeit controlled substance conviction out of Manistee, which to my understanding would be a low severity felony. He's no misdemeanor record. So he gets 15 points on that because he's also on probation. As far as this case goes, he does have a pending charge in Grand Traverse County for possession of cocaine, but that has not resulted in a conviction at this time.
Your Honor, it does not look like our office has run scoring yet. However, this is a 20-year felony that he's facing, and I am.
Well, it's charged as 7401-2A4, which is an E grid. Or a D grid rather, I'm sorry.
It's a 20-year felony as charged, and then we did just find out about this Manistee conviction. So we do intend to add a second subsequent, which would make it
Is that the Haida case?
Is it a Haida case?
Oh, no, wait. No,
Oh, he did have a
that's not.
Haida as well.
There was a Haida, yeah.
I didn't figure that in. I didn't think that scored.
Yeah.
And that was a while ago.
It's a, the Manistee conviction is May 20th of 2024.
And that's for it looks like delivery of a counterfeit narcotic.
Yes.
All right. The bond was originally set in this matter at $25,000 cash surety. A bondsman posted that. However, they've requested that bond be released. So I had signed that order back on March 18th. Given the missed tests and the fail to appear, the court is going to continue the remand.
Yeah, we can.
So we do have a signed waiver.
You want to waive prelim now? Mr. Harrison?
Indeed, we do, Your Honor. I'm sorry, I'm distracted.
All right, I have signed that back. Thank you. All right, court calls the people of the state of Michigan versus Connor Hall, case number 26-430 FY, and we don't have a prosecutor. Can we wrestle up a prosecutor?
I believe there's something going on here.
Okay. Oh, I mean, here comes Mr. Carnes.
Mr. Carnes.
All right, appearances, counsel?
Nick Carnes on behalf of the people.
May it please the court, Robert Champion appearing on behalf of Connor Hall, who is seated to my right, Your Honor.
All right, and we were here for, looks like a preliminary examination on a one-count complaint of possession of methamphetamine with enhancements. Is there any resolution of this matter?
Yes, Your Honor. It's my understanding the defendant will plead guilty to an added count of use of methamphetamine, and people will be dismissing the charge counts.
Mr. Champion?
That's my understanding of the plea agreement, Your Honor.
Mr. Hall, have you heard what the attorney said the resolution of this case is?
Yes, Your Honor.
And is that how you wish to resolve it?
Yes, Your Honor.
Will you please raise your right hand as best as you're able? Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Put your hand down. So it's my understanding that you'll be pleading guilty to an added count 2 of use of methamphetamine. That is a misdemeanor punishable by up to 1 year in jail and or a fine of $2,000. In exchange for that, the people will be dismissing the possession of methamphetamine, which is in of itself is a 10-year felony. They'll also be dismissing the subsequent, which makes that 10-year a 20-year felony. And in the alternative, you are also charged as the habitual fourth, which makes that 10-year a life offense. Is that your understanding of the plea agreement?
Yes, Your Honor.
Back on January 8th of this year, were you on probation or parole?
It's on parole, Your Honor.
Has there been a violation done? There has been.
He has been violated and served that sanction.
All right. And were you on bond in any other file?
No, sir.
Right.
No.
Do you understand that you have the right to a jury trial, the right to have witnesses called for your defense at trial, the right to cross-examine all witnesses called against you, the right to testify or to remain silent, not to have that silence used against you, the right to be presumed innocent unless proven guilty beyond a reasonable doubt? Do you understand those rights? Do you also understand that by entering a guilty plea today, you'll be giving up those rights and you won't have a trial of any kind?
Yes, Your Honor.
Other than the plea agreement, has anybody promised you anything in order to get you to plea?
No, Your Honor.
Has anybody threatened you in any way?
No, Your Honor.
And is it your own free choice to plead today?
Yes, Your Honor.
Are counsel aware of any other promises, threats, or inducements not made part of the record?
No, Your Honor.
I'm aware of none, Your Honor.
And Mr. Hall, to the allegation that on or about January 8th, 2026, in the city of Cadillac for Wexford County, how do you plead to an added count 2 of use of methamphetamine?
Guilty.
In order to accept that plea, I must have you tell me what it is that makes you guilty. So back on January 8th, were you in the city of Cadillac?
Yes.
And while in the city of Cadillac, had you used methamphetamine?
Yes.
And how was it that you knew that it was methamphetamine?
I knew that was not.
Yeah.
I've been using it and I went to report actually, and then I was 30 job duty for methamphetamine also. And that was part of my detainment as well.
So stepping a little outside of the bonds of the plea agreement, did they find methamphetamine on you as well?
Then not my parole agent does not know.
But did law enforcement?
They went to my home and that's where they found that, and she had called an officer, and that's where this stemmed from.
So they did a search of your home and found it. Okay, I wanted to make sure it wasn't coming out of a test. So that's why I asked that question. Okay. And you use that while in the city of Cadillac?
Yes.
And you had no lawful reason to use that?
No, no.
Do counsel believe defendants provided the factual basis in which to accept the plea and the court rules being complied with?
Yes, Your Honor.
I believe so, Your Honor.
As does the court, I find the plea is knowing, voluntary, and accurate. Mr. Hall, I find you guilty of use of methamphetamine pursuant to the plea agreement. The charged offense of possession of meth as a second subsequent, or in the alternative, as a habitual fourth, will be dismissed at the time of sentencing. Are we able to sentence today?
Yes, Your Honor.
Mr. Champion,
We are, Your Honor.
allocution?
Your Honor, so the court's aware, my client has been sanctioned, as we said, by DOC in this matter, including period of incarceration and treatment. He has completed that treatment. At the time this warrant was issued, he'd already completed both of those and was doing quite well. And given feedback from the Michigan Department of Corrections and its parole agent, he is doing quite well. As well as a relapse, he is taking full responsibility.
Thank you. Mr. Carnes?
Thank you, Your Honor. I was able to speak with Ms. Simmons from the DOC this morning about this, and she did confirm what Mr. Champion said, that the defendant was sent to rehabilitation program, was released, and I think now I'm doing math, was probably being supervised for a couple of weeks, but was doing quite well during those couple of weeks post rehab. Because of that, I would ask the court to impose 24 months probation. I realize that'll be dual supervision, but I think this court has, quite frankly, has a full year at its disposal, which the DOC has some constraints and is not. So I hope Mr. Hall does well over the next 2 years, but in case he doesn't, this court has more avenues for punishment. Thank you.
Thank you. Mr. Hall, you have the right to address Mr. Champion. Did you want to respond?
Just so the court's aware, he's only on probation, or excuse me, parole until October of this year.
Okay. Thank you. Mr. Hall, you have the right to address the court prior to sentencing. Is there anything you'd like me to know?
I just would like to add that I've been attempting to get an ADHD diagnosis since I was like 17. I finally got that diagnosis and then getting treated for it. I hope that I can display that that's working for me And I'll be able to display improvement for the courts. And then I can agree, with a 2-year probationary period, I think everything will work out just fine, Your Honor.
How long had you been on parole before this occurred?
I was granted a 1-year parole outside of prison, from October 30th of last year to this year, October 30th.
So you had roughly just about 2 months under your belt, 2.5 months before you picked this up? Did you say October of 25 you were put on parole?
Correct. Yeah.
Okay, and this is alleged to have happened January 8th of this year. How long did you go to rehab?
31 days I was in rehab.
All right. And what have you been doing while you were on parole? Are you employed?
I'm on disability.
Okay.
My day one out of rehab, in between the ride here, or the ride from rehab to come report, I already was filling out applications. I didn't even know I had a warrant. And then I got here and said, "You got a warrant?" I said, "Okay." I was very nervous. I wasn't prepared for it whatsoever. This is, I brought it on myself, I understand.
So when did you get out of rehab?
March 2nd.
Okay. And so you've been in for roughly, excuse me, 22 days. How are you, having just been out of rehab and essentially going right to jail? How's that been going for you?
It wasn't ideal whatsoever, I promise you that, but I mean, I still have the full intent to find part-time work and just to continue doing better.
Did you have services lined up for when you got out of rehab?
AT Addiction Treatment Services, it is out of Traverse City, but I had appointments lined up. One was for today, but we had to cancel that. And then I had Cadillac Primary Care. I had a doctor's appointment set up for tomorrow. Or no, the 31st, I apologize.
Next week, okay.
And then, those were it. I was gonna see what was gonna happen with that doctor's appointment, see if maybe I need to go with CHS, and maybe my parole requires I do CHS. I haven't really had the chance to sit with her just yet.
So the ATS aftercare that you were gonna do, was that in Traverse City or because I think they have a remote unit that comes
It
here
would
as
have
well?
been, yeah, remote Marcus, I forget his last name. His name was Marcus. We were gonna be in touch, and I was all on board with it. And in regards to the beginning of me being in trouble, the 24, I was very reluctant. Against everything, but I've learned to open up and be more with the conversation of me seeking help. And I'm giving it my all now as of lately. I mean, I've been trying my best.
So it looks like was it May of 23, you were sentenced to 13 to 120 for the possession of meth?
23, yes, but 23. The chart, I've been having a lot of mental health things going on, so sorry if my dates are a little confusing for me.
So you would have done
I did a total of 25 months.
25
concurrent
months.
with my first possession and my second possession.
So they were concurrent, they ran together?
They were ran together.
All right, okay. Anything else you'd like me to know?
I'm just trying my best, John.
All right. Well, normally where you're on DOC supervision, I wouldn't put you on supervision in this court because there's more that they can do for you than what we can. However, you've only got, in the grand scheme of things, a few months left on DOC supervision. I realize it runs out in October, but that's going to go pretty quick. So I am going to, I'll put you on a period of probation here for 24 months. During that time, you're not to violate any law, report as ordered, not leave the state without the consent of your probation officer, and to keep your employment and your contact information current. Now, even though I'm putting you on for the 24 months, you do have the ability to be released early if you've done everything that we ask you to do at the halfway mark.
Okay.
So come 1 year, it's possible you could be released. Does that make sense?
Yes, sir.
Now, if something happens that your probation officer doesn't think you should be released, but you think you should, you can file a petition on your own. We'll have a hearing and I'll make that determination. During the period of time that you are on supervision here, you are not to consume any alcohol, no illegal controlled substances, and no recreational marijuana. Then you'll be subject to testing pursuant to the probation officer. And I will allow DOC and the district court probation to kind of work together on your testing. All right. I'm also going to order that you attend any counseling that she feels is appropriate, including for drugs and alcohol. Some of that might be overlapping with each other. So if you've already done programming, let her know that, and then she'll make the determination as to whether or not additional programming is necessary. Any additional programming that she feels is appropriate. I'm also going to, are you doing, or do you have plans to do NA or anything like that when you get out?
I promised my mother I'd do an A once a week, so I gotta do that.
Is that mom smiling at me in the back row there?
Actually, once a week or once a month?
Gotta be once a week.
Well, see, you're already, yeah, right? All right. So I am going to order that you be in some sort of recovery program.
Okay.
All right. There is a $75 Crime Victims' Rights Fund fee, $50 state minimum fee, $150 fine. I'm going to waive the court costs. Attorney fees, Mr. Champion.
I'd waive that also, Your Honor.
Attorney fees will be waived. I'm only going to charge 12 months of probation. If something happens that you end up staying longer than that halfway mark, you'll have to pay the monthly fee on that. But the probation is $360. Be 22 days jail with 22 days credit. Because you do have the 22 days jail, you're entitled to $5 per day back to that towards your fines. So that's going to be a credit of $110 back towards your fine. Mr. Carnes, anything I've missed in the judgment of sentence?
There we go. Thank you.
Mr. Champion?
Thank you very much.
Mr. Hall, any balance that remains unpaid for more than 56 days will have a 20% penalty added to that, but I'm going to waive that 20% while you're on probation. Okay? And because I have sentenced you to term of incarceration, even though it's time served, you do have the right to appeal that decision. And if you decided that you wanted to appeal it, you've got 14 days from today's date to request the appointment of an attorney. Do you have any questions for me about your sentence today? So when you're released today, it's probably going to be too late for you to get over here to the district court probation office to get signed up for probation. So you're going to want to report first thing in the morning to get signed up for that.
Yes, sir.
And I don't know if you'll need to report for DOC probation or parole or not, but if you do, make sure you do that as well.
Yes, sir.
All right. All right. Good luck to you.
Thank you, man.
Parents counsel.
Nick Carnes on behalf of the people.
I'm Jeff Harrison. I'm here on behalf of Mr. Cavazos. He's joined me at the table.
Counsel, we're here for a probable cause conference. Does not look like there's a resolution. Am I correct on that?
That is a correct determination, Your Honor.
And Mr. Harrison, you're requesting preliminary examination scheduled for April 7th.
About that, Your Honor, I had originally approached Mr. Carnes to adjourn that, again, for the same reason. I'm not going to be available on the 31st. For the record, we did seek to waive the prelim, but Mr. Carnes didn't want to. So we are going to have a prelim in that case. It'll just be on the 7th instead of next week.
Mr. Carnes, any objection to setting it for the 7th?
No, Your Honor.
All right. I know Mr. Cavazos has some cases pending in the circuit court. Are those still in the pretrial phase up there?
They are, and we're kind of treading water because we anticipate the likelihood of this being bound over is relatively high. So we're trying to get everything at least in the same end of the pool.
Okay. Are there any discovery issues we need to talk about or witness issues?
Your Honor, I think we just submitted a protective order that might still be processing before we can get.
I signed that yesterday.
Yeah,
Okay.
so I haven't seen it yet.
But we've sent everything else to IDC.
Mr. Harrison, will the 7th give you enough time to review the CAC?
It likely will.
All right,
Yes.
Mr. Go ahead, I'm sorry.
I forgot what I was gonna say, I'm sorry.
Mr. Carnes, you're not aware of any witness issues at this point? Then we will keep this, we will move this then to the 17th. I'm sorry, the 7th. The parties note that they waived the 21-day rule on the sheet, so we're satisfied with that. Anything else we need to address, council?
No, you're.
I don't think so right now.
All right, then we are adjourned on that case. So 26859 FY appearances council.
Nate Carnes on behalf of the people.
And I'm Jeff Harrison. I'm here on behalf of Mr. Shamus. You will see that Rob Hartel is the attorney of record here. There was a pretrial sheet form that had been turned in. So I'm just sitting in to address whatever questions the court has at this juncture.
All right, so we're set for probable cause conference. I just want to remind council that there were a couple of civil infractions that went along with this.
Right.
Refusal of PBT and failed to disclose to law enforcement CCW or a concealed weapon in the vehicle.
Do those deadlines on those civil infractions track along with this case?
They're tracking with the case.
Okay.
I happen to be looking at the pretrial sheet or PCC sheet. And I see that on there, there's an OWI second that he would plead to, and I realize that's not, it says it is accepted. But there's not one charge. Mr. Carnes, you,
Your Honor,
that's about-
there's probable cause to charge OWI, but there's no blood lapse. Defendant is apparently interested in sobriety court, and if that's what he wants, a plea to this would be appropriate. We do have video evidence, officer testimony, et cetera, that would support that.
I note the Prudentville address. Is he a resident of Wexford or Missaukee County?
No, he lives in Roscommon County. And we obviously would not be in a position to resolve the case today anyway, due to the lack of a substance use assessment.
Okay. I know you guys are aware that I very, very, very rarely will transfer to another sobriety court
Right.
because of hiccups we've had along the way. So I'll just be upfront, the chances of this happening, if he were accepted in another sobriety court, of me transferring to him another sobriety court is very slim. So everybody's
Yes,
aware of that.
I wasn't aware of the out of county residency.
Oh, okay.
Yeah.
Sorry to hold the court up
No, you're
on
fine.
this. We do have another offer that is likely to result in a plea. I would propose we simply set the case for a plea and sentence.
All right.
This original sheet had indicated. Don't think we need 3 weeks on this anymore.
My guess is that was for sobriety court.
Yeah,
Yeah, we can just submit a new sheet.
so we will do that today, Your Honor.
Do you want this set next week or do you want?
Let's set this.
Oh, no, I'm sorry. We can't do it next week. I forgot. So it'd have to go a week
Well,
out
it's
after.
neither of our cases, so if that's the.
So let's go out 2 weeks.
Okay.
Let's do this.
Okay,
This is what I'm gonna do. We're gonna reset it for another probable cause conference.
okay. And that should resolve everything, Your Honor.
That'll be next week though, right?
Making no paper date next week.
Yeah, so just so everybody's aware, the PCC next week will be a paper day.
Yes. 'Cause I won't
Um,
be here.
Yeah.
Yay.
All right, anything else we need to address?
I don't think so.
All right, Then, sir, just a reminder that your bond conditions continue. Okay, you can go out to the front window where you checked in and get your next court date.
All right, thank you.
All right, thank you. That completes the morning doc. Appearances counsel.
Please sit all for the people.
And I'm Jeff Harrison. I'm here on behalf of Mr. Winsky. He's joined me at the table. Well dressed.
All right, you may have a seat. Counsel, we are here for a preliminary examination on a operating while intoxicated as a third offender. Is there any resolution to this matter?
There is, Your Honor, well, not today.
Okay.
Your Honor, the people have made an offer of if defendant were to plead to operating while intoxicated, second offense, and child abuse fourth degree, we would dismiss operating while intoxicated third offense.
That's my understanding as well, Your Honor. We would simply have the court set it for a plea and sentence.
We'll go ahead and set that for a plea and sentence. It won't be next week. It'll probably be the following week.
That would be my preference as well, Your Honor.
You guys have to refuse a PBT ticket.
Oh, yes. There's also the civil infraction of refusal of the PBT. Is that under consideration?
You would have to resolve that one.
All right.
Okay.
Okay, sir, you can go out to the front window where you checked in and get your next court date, and just a reminder that your bond conditions continue.
That's right.
All right. Next, Wexford County Jail, please state your name for the record.
James Richard Holmes Jr.
All right, this is case number 26-446SM. The people of the state of Michigan versus James Richard Holmes Jr. Sir, you met with somebody from Community Corrections and gave them some contact information. Was that information accurate?
Yes,
And did you have the opportunity to meet with somebody from the Public Defender's Office today?
yes. I think,
I have a complaint that alleges that on or about January 21st, 2026, in the city of Cadillac, it's alleged in count number 1 that you committed the offense of domestic violence upon a person with the first name of Tammy as a second offender. That is a misdemeanor punishable by up to 1 year in jail and or a fine of $1,000. In count number 2, it's alleged that you committed the offense of domestic violence as a second offender upon a person with the first name of Joseph. That also is a misdemeanor punishable by up to 1 year in jail and or a fine of $1,000. Do you understand those charges and the potential penalties?
I do.
You do have the right to be, so did you read and sign an advice of rights form there at the jail talking about your rights to an attorney and your rights to a trial?
Yes,
Did you understand those rights?
I do.
You do have the right to be represented by an attorney at all phases throughout this process. And if you could not afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
I'm gonna request the appointment of an attorney.
The court will make a referral to the Public Defender's Office for the appointment of an attorney. We'll enter a not guilty plea and we'll set the matter for a pretrial. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Ms. Fervento, I show in 1989, there was a possession of narcotic paraphernalia. In 11, there's a case that Lena isn't really clear on, but I think it was handled under 4A. He scores a 3 on the praxis, and the prosecutor's office filed a request for bond conditions in that they are requesting that the defendant not purchase or possess any firearms or dangerous weapons, that he not have contact with the 2 persons listed in the complaint. And the reasons for the request is the pushed victim TM and punched victim GK in the face, causing a bloody nose. Defendant is victim TM's boyfriend, and they reside together. Any comment regarding bond? Ms. Fiorvento?
Thank you, Your Honor. We would respectfully request a personal recognizance bond hearing. No objection to the conditions mentioned. Praxis score is 3. He reports that he voluntarily turned himself in. He learned of this warrant while applying for jobs and went and turned himself in because of that. And consider that he has a low risk of flight, and we respectfully request a personal recognizance. Thank you.
All right, thank you. Based on the amount of time that's passed since these allegations have arose, I also note that there is now a PPO with one of the alleged victims, so I am going to do a personal recognizance bond, Mr. Holmes, which is your promise to come back to court with the conditions that you appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. I am going to order that you not have any contact with the 2 persons listed in the complaint with the initials of TM and JK. Those names will both appear in the pretrial release order. No contact means no contact of any kind, not by phone, text, email, social media, or anybody acting on your behalf. If you are found to be in violation of your bond conditions, you could be arrested without a warrant, brought back to jail, and have your bond revoked. I am also going to order that you not purchase or possess any firearms or weapons, and that you not act in any threatening, intimidating, or harassing behavior. All right. At some point, you'll be released from the jail today, but before you're released, you should have your next court date. So make sure you keep track of that court date, okay?
Certainly will.
All right, thank you. Next arraignment. Person at the jail, please state your name for the record.
James Farvey.
Mr. Farvey, are you a third?
Yes, sir.
All right. You met with somebody from Community Corrections today and gave them some contact information. Was that information accurate?
Yes, sir.
Did you have the opportunity to meet with somebody from the Public Defender's Office today?
Yes, sir.
I have a complaint that alleges that on or about July 1st, 2025, in the city of Cadillac of Wexford County, it is alleged in count number 1 that you committed the offense of controlled substance possession of methamphetamine. That is a felony punishable by up to 10 years in prison and or a fine of $15,000. The prosecution is also elected to charge you as a controlled substance second or subsequent offender, meaning that you have at least 1 prior drug conviction in your past. That makes that 10-year felony a 20-year felony and or a fine of up to $30,000. In the alternative, they have charged you as a habitual 4th offender, meaning that you have at least 3 attempted or completed felonies in your past. That makes that 10-year felony punishable by up to life. Do you understand those charges and the potential penalties?
Yes, sir.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning you consent to, and the right to stop answering questions at any time. You also have the right to be represented by an attorney at all phases throughout this process. And if you could not afford one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of one?
I can't afford one.
So do you want the court to make a referral for a public defender?
Yes, please.
All right, the court will make that referral, enter a not guilty plea, and will set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecutor is required to prove 2 things. 1, probable cause that the crime had occurred, and 2, probable cause that you were the person who had committed the offense. If the prosecution is not able to do that, the case would be dismissed. But if they are able to do that, you'd be ordered to stand trial in circuit court. Prior to the preliminary examination, there'll be a probable cause conference. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Ms. Fiorvento, historically, I show in 22 a use of a controlled substance. Another one is use of meth in 22. And in another 22 case of possession of meth and attempt to resist and obstruct. In 23, a driving license suspended. 24, possession of meth and possession of analog. In 06, there was a fail to stop at a property damage accident and reckless driving, and also a no license. I show that he's currently on parole until July of this year for possession of methamphetamine. Any comment? The praxis scores him at a risk level 7. Any comment? Well, I should say that the prosecutor's office also filed a bond request. In this case, they're requesting $100,000 bond with the conditions that he not use alcohol, marijuana, or illegal controlled substance, that he be submitted to random testing, that he not have contact with the co-defendant in this matter. And the reasons for the requests are 2 methamphetamine pipes with residue found on defendant, extensive criminal history, and was on parole at the time of the offense. Any comment regarding bond?
Thank you, Your Honor. The defendant reports that he is disabled and suffers from a plethora of health issues. He lives with his mother and he has very little means. In consideration of all that, we would just respectfully request a low bond or a low 10% if the court would be so inclined. Thank you.
You know, was or is there a parole violation happening out of this?
I believe Mr. Harris is the attorney on that. May I consult with him briefly?
He has an existing case on similar charges that I believe is at the pretrial stage in circuit court.
But it's separate from this then?
It must be. I was unaware of its existence until 30 seconds ago.
Do you know, does he have a parole violation? Or had he had one?
I was checking to see, and I can't confirm the parole hold right now. I might be able to with my actual computer.
Corrections, do you know, is there a parole hold on Mr. Farby?
I'd have to check, Your Honor, one moment.
Thank you.
Your Honor, there is currently a parole detainer.
All right, thank you. All right, because the defendant does have 2 or more felony convictions in the last 5 years, it is required that I set a monetary bond. Bond will be set at $25,000 cash surety with the conditions, Mr. Farby, that you appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. I'm also going to order that you not consume any illegal controlled substances, including recreational marijuana, and you'll be subject to random testing for those as well. I do believe that these conditions are appropriate, given that the defendant was on parole at the time that the allegations are alleged to have happened. Thank you, corrections.
Thank you, Your Honor.
PC Raymond, so we're up to the 2 o'clock docket, so we'll be in recess.